Thanks, Kieran Corley. Again, I'd reiterate our welcome of the fact that the government is not opposing this bill. In and of itself, that demonstrates the change that has taken place. 3 years ago, the government voted down a bill that was weaker, that was less far-reaching in the Seanad, and it's a change that has not taken place from above, but has taken place from below, from movements of tens of thousands of people campaigning for an end to homophobia, to discrimination and against inequality, and in particular it reflects the change that the marriage equality referendum reflects and has now become part of. It is clear that the government's intention is to have this bill pass second stage, but then effectively to gather dust, and instead to proceed with the bill that was introduced into the Seanad. We're not precious about our bill because it's from the Anti-Austerity Alliance, but we are insistent that a minimal approach, an approach that simply raises the bar for discrimination but maintains discrimination, is not acceptable, and it won't be accepted by those who campaigned for marriage equality. A bill which maintains, and an act which maintains the right of discrimination against workers in education, in healthcare, in charities and elsewhere. And this debate now in reality will turn to the bill that was introduced by Ivana Bacik and the weaknesses that exist in that bill. The protest that happened this evening was welcoming of the fact that the government that this bill will pass second stage, but is now focusing on the weaknesses that exist, and that's what I want to focus on in the few minutes that I have. The first key weakness in that bill, as we see it, is that it draws a distinction between services that are publicly funded and those that are not. We do not see why workers in services that are run by religious orders that are not publicly funded should be allowed to discriminate. We don't see why those workers should be entitled to less rights, employment rights and equality rights than workers in services that are publicly funded. Nowhere else in employment law is that distinction between public and private workers and privately funded workers take place. For example, the Bacik bill would mean that in an educational or medical service which is under church control or run by the church but is not publicly funded, could continue to discriminate against someone because of their sexuality, because of their religion, because of their status in terms of being perhaps a single parent. It would mean that a lecturer in a privately run third-level institution could be discriminated against because they're seen to be openly gay, and that goes against the religious ethos. So we think it's the wrong distinction to be made about whether there's public funding or not publicly funded. We think the proper distinction to be made is between a religious institution or religious order itself and the running of its own affairs versus the running of a service, whether that is publicly funded or not, whereby there should be no discrimination whatsoever and no grounds for discrimination in a service run by a religious institution, be it educational or health or anything else. The second major flaw is that the religion ground is maintained as a grounds for discrimination, even regardless of whether it's publicly funded or not, but with a higher bar whereby it would have to be a genuine, legitimate and justified occupational requirement. So even if a school is publicly funded, a religious order could make the case in the school that they control that religion is a justified ground for discrimination because, for example, a teacher may be required to teach religion and could therefore discriminate legally against someone. And that discrimination would still exist if the bill isn't amended and was then enacted. In the first place, that's clear discrimination against atheists and against those of a religion of a different sort than that which controls the institution. But in the second place, it may also be a backdoor grounds for discrimination against LGBTQ people, for example, who could be said that by being openly gay, that isn't in conformity with the teachings of a certain church, therefore they are not of that certain religion, and then be discriminated against on the religion grounds on the basis that they meet that justification. There should be no discrimination whatsoever in any services run by the church, like education or health. The only grounds for discrimination, we think, should be on the grounds of religion within the religious institution itself. We think that does meet the needs of the Constitution, which refers to the right of religious denominations to run their own affairs. We think their own affairs does not extend to the running of schools or hospitals or others, but literally their own affairs, and therefore the right of religious orders to discriminate in favour of people of their own religion, for example, when it comes to appointing priests or ministers or anything else. I just finish on the point that I would urge the government that the marriage equality referendum, it showed that the demand that exists is for equality. And those who mobilise for equality will not tolerate half measures. The demand was yes equality, not yes to half equality. The Irish Council for Civil Liberties, in remarking upon the bill that was in the Seanad, made the point that equality is a binary state. Either one is equal or one is not. And as the ICCL's view, the Oireachtas should seize the opportunity to eradicate all forms of discrimination. We need full employment equality. We don't need a higher bar for discrimination, and we need it before next September. Thanks.
Thank you. I now put the question that the